having represented many husbands in false cases filed against them by their wives, as an advocate practicing in India, these are my thoughts on marital rape. Why shouldn't we recognize marital rape as an offense in India? People talk about the potential for abuse. When there is a marital relationship, there is an expectation of sex, and that is why it would be very easy for a wife who is angry with her husband to go and file a false rape case against her husband. Well, I ask all of you, what law in this country does not have potential for abuse? There are many laws which are passed in this country for the benefits of certain marginalized sections of society. And when there is any sort of legislation which is passed for the benefit of one society, there is almost always on the other end, the receiving end, a group of people from the not so marginalized community who face false cases from time to time. Does that mean that we strike off the offense in entirety? By that same analogy, we could make rape itself not a punishable offense. By that analogy, we could say that any atrocity committed upon a person of the scheduled caste or scheduled tribe community should not be punishable. By that analogy, even a case of cheating should not be punishable. Because what about the potential for abuse? In this situation as well, the fact that you do not even allow a wife upon whom sexual violence has been committed to report a case, it is not a cognizable offense, the police cannot register a case. These are all things which are very absurd. People also say that if convicted falsely, an innocent person could go to jail for a minimum of 10 years. I again say to that, if there is enough ample evidence produced by the wife against a husband who has perpetrated sexual violence upon her, he might as well go to jail for 10 years rather than him actually perpetrating an offense and the wife having ample proof. But because the legislators fear that this will break down the sanctity of the marriage, is an absurd line of thinking. But I do have 4 major concerns about recognizing marital rape as an offense in India. And the problem is not with recognizing marital rape in India, but the way the criminal justice system works. But for us to say, let us not recognize marital rape as an offense in India because we have many issues with the criminal justice system is again an absurd reasoning. The problems which I'm going to be talking about, if we can fix them, I believe marital rape, a severe offense, as grievous as any of the other offenses for which a minimum imprisonment of 10 years is given, should be implemented. The case should go to trial and the person, if found guilty, should be sent to jail for 10 years. Because whenever I have clients who face false cases of dowry harassment, false cases of rape, and I have represented many of them. Whenever they come to me and they lament their situation, they say, what kind of a situation am I stuck in? All of these false cases, I have to remind them. And when I do, they agree that these legislations are indeed beneficial for the entire society. There were a lot of atrocities committed upon women in the past centuries, and that is why these legislations are important. Just because there is a potential for abuse does not mean that you will do away with the legislations altogether. But anyways, we come to the 4 problems that are there with the criminal justice system, because of which marital rape, recognizing it as an offense, would be a bit of a difficulty. And that is why I propose that we bring change to these problems with the criminal justice system and then recognize marital rape as an offense. The first problem is bail. As the situation stands right now, the moment there is an allegation made against a person, especially a man in a rape case, before the police will, in a lot of cases, immediately go and arrest the accused person. And that is a problem because in every relationship between two human beings, between a man and his child, between friends even. There is bound to be a little bit of friction because that is what human relationships are. But if there is friction and one person has the power to go and send someone to jail in custody for several weeks, months, or years on the basis of simple statements, that is unacceptable. To that, people might say you always have the remedy of applying for anticipatory bail. Again, the problem with anticipatory bail is that wherever we look at the jurisprudence of anticipatory bail, all the principles say at the end of it, after discussing everything, the Supreme Court always boils it down to it is the discretion of the court. And literally, the Sessions Court or the High Court could be saying this: you know what, I completely think you're innocent, but anticipatory bail is a discretion which I may or may not choose to exercise in your favor, and here I decline. Which happens on a lot of occasions, especially when it comes to rape matters. And therefore, I say that there is a possibility for abuse, and if an allegation is made immediately, the accused husband goes to jail, that becomes a problem. The second problem that I have is that whenever a criminal case is initiated, it is the police who have complete free hand in doing whatever they want. Neither the complainant nor the accused person have any right of say to push the investigation into a specific direction. The investigating officer is the boss. He can demolish the entire case of the complainant. He can demolish the entire case of the accused person if he so wants. And therefore, at the end of the day, again, if you give a lot of unmitigated power to an individual or to an institution, there is bound to be abuse. Because of which, what happens, and I've seen this while defending so many people across the board in criminal cases, we go to the investigating officer with all our proof and we say, please consider this evidence as well when you are investigating into this matter. And often, the investigating officer completely disregards the evidence of the accused person and says, I am not going to add or include any of the evidence given by the accused in the complaint of the complainant. You go and you take your defense at the appropriate time. What happens then? You either bribe the investigating officer, or if you are a law-abiding citizen and you do not want to indulge in corrupt practices, then you wait for the charge sheet to be filed. You argue on charges, and again, when the charges are being argued, the scope is very, very narrow. All that is there in the charge sheet only will be considered and nothing else. And then the trial court will issue notice to the complainant to appear, to all the prosecution witnesses to appear. You pay your lawyers to cross-examine all of these prosecution witnesses. And after that, your statement under section 313 of the Criminal Procedure Code will be recorded, after which you are allowed to testify yourself and to bring in your defense witnesses. The difficulty with this is that until that time of defense evidence comes, you have spent anywhere from 3 months to 13 years defending this false and frivolous case, if it's a false and frivolous case. Till that time, everywhere you go, you apply for any government job, you apply for passports, visas, anything at all, anywhere at all, there are massive curbs on your freedom, on your liberties to move around. Everywhere an aspersion is cast against you being an accused person. And you also, of course, spend a lot of money on the lawyers as well. If we could have a system of amendment of maybe the Criminal Procedure Code, which is being recently proposed by the legislatures in the parliament, that if at the very outset itself, the accused person has sufficient evidence, sufficient material to show his innocence, that must be considered by the investigating officer. And if not done so, at least the courts of law can intervene and direct the investigating officer to consider all of this material aspect. The third difficulty that I have with the criminal justice system, because of which recognizing marital rape as a punishable offense will be a problem. The Evidence Act says that if a woman alleges that she was raped by a man and it is proved that the said woman and man indeed have sexual intercourse, then the age-old tenet of criminal jurisprudence, that is presumption of innocence until proven guilty, that is taken away from the accused person. And the Evidence Act says that it will then be the duty of the man to prove that the said sexual intercourse was indeed consensual. The practical problem in layman terms with this is that in a criminal trial for marital rape, after recognizing it as a punishable offense, if the wife testifies against the husband and says that he forced sexual intercourse upon me, the husband cannot deny that sexual intercourse did indeed take place between him and her in 99% of the cases. And because the husband cannot deny that, there will come upon the husband the burden to prove that this sexual intercourse between him and his wife was indeed consensual. And again, how does one prove that this sexual intercourse that did transpire between the man and the woman was indeed consensual? And if he's not able to prove it, he goes to jail for 10 years. And my final difficulty with recognizing marital rape as an offense is the possibility, which no one is considering right now, of trivializing the offense of marital rape to the same extent that it stands today. What happens is that a law is passed for the benefit of a marginalized section. The police, of course, are always there to use it and to often abuse it. The judiciary then keeps watching, keeps denying bail to accused persons, keeps convicting accused persons, and keeps seeing the abuse of this particular social welfare legislation by especially the police more than anybody else. And then the judiciary steps in and puts in checks and balances in place, because of which the police take a complete U-turn and stop taking any action in those kind of cases where they were earlier arresting people left, right and center. For example, unnatural sex under section 377 of the Indian Penal Code. For several years, when a wife wanted to file a false case against her husband, she was able to invoke dowry harassment laws to get her husband arrested. When the courts stepped in and started granting anticipatory bail to everybody, and then also mandated that if a complaint is filed by a wife, this must go first before the Crimes Against Women cell, lawyers started drafting in the complaint filed by the wife allegations of forced anal and oral sexual intercourse, upon which the police started immediately going and arresting husbands under section 377 IPC. After which the court started granting anticipatory bail and also started reprimanding police officials for arresting husbands under section 377 IPC for forced anal and oral sex all the time. Because of which now, and I have seen this in many cases, even if there is any allegation of forced anal or oral sexual intercourse by the husband upon the wife, which is still recognized as a punishable offense in India under section 377 IPC, the police completely disregard it. The FIR almost always mentions only sections 498A, 406 and 34 IPC. There is no mention of section 377 or of any other allegation which could have been leveled, which could be true, by the wife against the husband or his family members. I can imagine a scenario where marital rape is recognized as an offense and there are a lot of false prosecutions, after which the judiciary steps in and reprimands police officers and threatens them with action. And because of this, right now we have a situation where marital rape is not recognized as an offense at all. And after a few months or a few years, this thing will again be trivialized and we will be back to square one, where even if an allegation of marital rape is made by a wife against the husband, there will be no action taken by the police. If we are able to fix these situations, I believe recognizing marital rape as an offense will give the wife who has truly been subjected to sexual violence some recourse, at least an attempt to get justice for the atrocities committed upon her.